Yeah, I too am a copyright ignoramus. That's why events like this are really good. We can catch up on it. But, that's the thing about working for a big media organisation, isn't it, Megan? We don't have to worry. We're fully indemnified, surely. We can do what we like.
I don't think that's true.
That bit wasn't going out, was it? No, okay. Just kidding. Okay, we have 5 panellists today. We're going to talk about the future of copyright from now. We go through till 4:45, so the last session of the day. And then it's networking and refreshments, I think, after that, if you can make it through. So we will be talking about where to from here. And we have 5 panellists today to reflect on this day of discussion we've had about the challenges and opportunities facing copyright in the coming years. So we'll talk about what might change, what needs to change, and what we should all perhaps be thinking about as creators, users, and citizens of the internet. And I suppose there's a few policy advisors and lawyers in the room too who might actually have a role in shaping that too, with our law currently up for review. So plenty to talk about. So our panellists today, Pia Andrews is here. Pia, now you can correct your bios as I read them out. I'll give you an opportunity to do that because it's always embarrassing if you get it wrong. An open government and data ninja who works to enable greater transparency, democratic engagement, citizen-centric design and pragmatic innovation in the public sector. Right so far? Cool. She believes that tech culture has a huge role to play in achieving better policy planning and a better public service all round, and strives to get greater public benefit from publicly funded data, software and research. And I guess, actually might as well come up here, and we've got 3 microphones. We have to share them around our panellists, but yeah, big hand for Pia. So I guess in trying to get the maximum public benefit, that would occasionally bring you into collision with the restrictive nature of copyright from time to time?
I have many stories.
Many stories, good. We look forward to hearing a few of them. Next guest, Graham Austin. Graham is here. He's the Chair in Private Law at Victoria University School of Law. His current research looks at the relationship between privacy and copyright, dignitary interests in copyright law, copyright exceptions and citizen journalism. Correct so far? Oh, good. That's good. And I heard Graham speak actually at an event called Balancing Copyright, which was held right here last October, and that was organised by the Screen Industry Association. And I went to that because I knew I was copyright ignorant and the law was up for review, and I thought if I just go to this one day, I'll get filled in on all this stuff and I won't have to do my own research and it'll be great. And Graham stepped up to speak about the history of copyright, and I kind of thought, do I need to know the history of it? I just want to know how the law is going to change, what the issues are right now. So I sat up the back and thought, I'll just use my phone and no one will know and I'll just tune out a bit. But it was a brilliant speech. It was really, really good. Graham should have his own show. It should have a Creative Commons license so we could all see it. It was really interesting. And when I got home, you'll be pleased to know I looked up the statute of Anne. 1709, 1710? 1710, the beginnings of copyright law. So, I urge you to check it out because it's actually a more interesting story than I certainly thought back then. Vanessa Blackwood. Vanessa, policy advisor in the Office of the Privacy Commissioner, who has a Master's in Human Rights Law focusing on censorship and hate speech. She lives in Wellington, and it says here you spend your whole life on the internet. That's a true fact? Yeah. Okay. All right. And actually, Vanessa saved the day for us at Nethui in Auckland last November, I think. We had a panel about trust and deception, and she filled in at the last minute for someone who's crook, so we're grateful to you for that. And you spoke about online designers and how they can actually focus more on privacy by creating services that collect less personal information about it. So often when you sign up for things, they're asking you for personal information when they don't really need it. I'm guessing that problem hasn't been solved between now and last November. No. Okay. Didn't we talk about the Wi-Fi on the Auckland Airport bus and how even they required your email and your gender? That's right. Yeah. So quite why they need to know your gender so you can use the Wi-Fi on the bus, I don't know. Right, an actual lawyer, we have Lynelle Tafrihuria is here. Great. And she is special counsel at AJ Park, who works with clients from all around the world. Her passions are Indigenous law and protecting cultural icons, including guiding clients on navigating clashes between our intellectual property laws and Matauranga Māori. Am I right so far?
Yes.
Okay. Were you involved in the Pātea Māori Club trying to protect their rights to
Yes,
poia?
I do work with Pātea Māori Club, yes.
What was the outcome of all of that?
So it's still ongoing, yeah.
But they're able to reap the benefits of having created that so many years after?
Yeah, they definitely do as a performer. They have rights as performers. They didn't write the song or the music, so they don't have those rights, but still navigating the issue of the fact that there's actually three parties involved, so it's a bit more complex than just one party owning that whole.
Because that held a whole
piece of work.
second life, didn't it, when the movie came out? Because the song goes back to 1980.
1982. Yep.
1982. Well, I remember that coming out, so that's it's a memory for me. But while we mention it, I mentioned the term there, mātauranga Māori. I had to admit I didn't really know what it meant. I mean, there's various definitions, literally Māori knowledge, particularly taking in the period of pre-European contact and so on. Some people, I think, use it almost interchangeably with te ao Māori, but that's not the right way to think about it.
No, I think that is the right way to think about it. I mean, mātauranga Māori is a post-colonial concept, if you go back to its true meaning. But when Māori use mātauranga Māori, they are all embracing of kawa tikanga, and that embraces things that go back beyond pre-colonisation. So it's a big concept and covers a wide area.
But it must be come to play in some pretty interesting legal action.
Definitely.
Cool. Okay, and our final panellist today probably doesn't need an introduction to anyone who's here for the keynote. That's Corey Doctorow. Come on up. Here's the microphone on the chair for you. Science fiction author, activist and journalist. Good so far?
So far, so good.
Approved, okay. Co-editor of the pioneering blog Boing Boing, and co-owner, in fact.
Yes, correct.
Yes. And author of many, many books. Your most recent one is Walk Away.
Also correct.
Okay, and writing about this, reviewing it, in fact, for NPR Online, one critic, Jason Sheehan, says Doctorow's writing is, quotes, super weird in the best possible way. You happy with that?
I think that is also correct.
Okay. That was his writing, not Corey himself. Also,
That is not correct.
No. Okay, but we've established all the facts. He also has another book, Information Doesn't Want to Be Free, which is partly about earning a living in the internet age. And that was something, of course, Corey spoke about for those who were at his keynote earlier today, where we also learned that information really doesn't want to be anthropomorphized.
Yes.
And that was a highlight for anyone who was hearing that speech. And in fact, myself and Corey have already had a chat for the Media Watch program on RNZ National, which, all being well, will go out this Sunday on the air and then online after that. And I can exclusively reveal a couple of bits of private information about Corey. One is you're fond of licorice all sorts. So this is not a thing in North America?
No, we have them, but specifically the buttons.
What, those gelatin?
With the blue beads or the pink beads. And
Okay.
Yeah, I don't have a color preference, but basically, like, if you feed a goldfish, it'll eat till it explodes. Just give me those. And
So the other things with the, the compressed sugar and coconut mashed together with this hysterical food colouring.
take them or leave them.
That's not your thing.
All
Okay.
about the buttons.
And the other thing I learned from eavesdropping on Corey recording a program for the ABC, which is yet to be broadcast in Australia, is he has sort of interesting attitude towards property rights when it comes to hotel pillows. So, having discovered a very comfortable pillow in a Western hotel in one Australian city, I think.
No, an American city. It was when I was on
city.
tour. I was changing cities every day and staying in a new Westin. And just like you can take the glass from the bar up to your room, even though, you move it from one part of the hotel to the other, it's still the same premises. I reckon that if I was leaving at 4 a.m. and needed a pillow to be comfortable for a snooze on the plane, I could just take the pillow from one Westin and leave it in the next.
So I'm thinking, is this kind of allegory about copyright and, transferable formats and platforms? It's not really, is it? No. Okay. All right. So that is not an important copyright issue, but let's address the things that are. Well, as has been mentioned a lot today, our copyright law is up for reform right now, under review. Most of it dates back to, I think, 1994. It has, of course, been amended several times since then, but not always in a way that really catches up with technology. So I thought I'd begin by asking our 5 panellists, about an aspect of copyright law they think we really need to retain or preserve, the existing framework that we have that may be common not just in New Zealand but other similar countries, and ones that we really need to get rid of and change. So I'll start, Corey, you're not steeped in New Zealand's own copyright law, I suppose, but you've made reference to Section 92 and things like that have cropped up in the past. But is there perhaps an element of current copyright law that you think, we've got to preserve it, and perhaps one that really has to go?
I am not familiar enough with New Zealand copyright law to speak authoritatively on this. I'm, as you've heard, not much of a fan of 92A, and I know that it's been pointed out that it has not been invoked very widely, and that there's a cost-shifting mechanism that stops people from trolling with it. I think that it is a ticking time bomb because it is a very cheap way to make people go silent on the internet, and I think it's only a matter of time until that gets abused. As a writer, I'm fully confident that a gun on the mantelpiece in Act 1 always goes off by Act 3. As to something to keep, I think the framework of limitations and exceptions and the notion of a public domain are both very important. The devil's always in the details, but the idea that copyright is a balance between the needs of people who create out of what's come before them and exclusive rights in the works that they make out of that stuff, that's an important notion that resides in most Commonwealth copyright systems, including yours.
Okay. And Linnell, are there elements of our current copyright law that really give you cause for concern, you think should be top of the list for any reform, seeing as it's under review right now?
I think I'm going to play a little bit of devil's advocate and go into what Corey just said around the public domain. And this is with particular focus on mātauranga Māori, because that's the area that I'm here to represent. And I think there is need for an exception for mātauranga Māori and recognising tikanga around not just Māori people, but Indigenous peoples around the world, their Indigenous knowledge and how that was traditionally recognised and managed by people, by Indigenous peoples. I think that's a real need in our legislation, and certainly I think Corey's talk this morning touched on recognising creators, and that would go a long way to recognising Indigenous creators. And so, I think the framework is great, but for me, the public domain is a real issue in terms of recognising mātauranga Māori.
Okay, and Vanessa, you spoke earlier today about that area of privacy clashing with copyright. Are there things you think should be top of the list for a review of the law as it stands?
I'll actually talk to a thing that I think should be retained in the law as it stands, which is anyone who came to my session earlier would have heard me talking about, which is around Section 105, which allows that if you commission a work, a photograph or a film for private and domestic purposes, even if the copyright is then held or owned by someone else, usually the creator, you still can exercise certain privacy rights over that work. So you can have it not exhibited in the public and not distributed. And I think that that's a very important recognition that, for example, if you want to have your wedding photos taken, or you want to have your child's school photos taken at school, or your family does, the Christmas cards with the ugly sweaters in the mall, you might not want that to then be used by the photographer to advertise their services on the side of a bus, you and your family all in your ugly Christmas sweaters. And I think that recognising the element of control for the subject of the photo is very important. So that's the one that I'd retain.
Uglychristmassweaters.com. You probably get lots of stock footage from the online picture agencies for that. Pia, is there something you'd like to tell us about? What do you think that are the elements of copyright law you think should be either retained or jettisoned at first opportunity?
So first, I just want to say the whole framework needs a rethink because it was based on a scarcity model from days when it was hard to copy and days when gone by. The whole system has changed, the whole paradigm we live in has changed, and if we don't actually take a whole rethink, then we're just going to iterate and then reinvent the past with shiny new things, which a few of you have heard me say before. But to go to the question, I think things that we can keep are the attribution aspect. I think it's important to be able to attribute things, particularly facts and evidence, to things, so that then you can start to have a framework for combating fake news, for combating fake information. I think that the transference to the public domain gets often lost. We went from very short amounts of control to very, very long amounts of control, and that's had quite an interesting impact. And I think that gets forgotten. Part of the point was to give a temporary monopoly to then be able to transfer these things to the public domain for everyone to innovate on, and that has been forgotten, I think. I think the third thing worth keeping is the individual empowerment, of course. It has been useful in empowering people to a degree, but then, of course, the flip side, we need to discard. I'm just going to share a very quick story. I was at one of the very early sort of Senate estimates inquiries in Australia about 3D printing, and the number one lobby group against 3D printing as a technology was the copyright lobby. Right? From their perspective, that threatens our business models. My argument is, why wouldn't we choose people and what we can do in terms of, actually eradicating certain types of poverty through lack of access to food and to goods over a business model? I think we have a system right now that actually puts business models, antiquated business models, above people, and I think that needs a rethink. So I'd get rid of that. I'd also get rid of how we use the state as an enforcement action for copyright. I think it's amazing that at the border of certain countries, if you've got something on your device that may be perceived as copyright infringement, that the state has an involvement in that. I think that's a little scary.
Yeah, at border controls and things.
Yeah, I mean, we're using the state as the enforcement measure for this at the moment. I think that's interestingly strange.
Is that often employed out of interest? Or I suppose would we even know if it was?
Depends which country you go to, mate. The final one is I'd like to discard the command and control. We aren't a castle anymore. We are a series of nodes in a network. So we need to actually look at different mechanisms for tracking, for supporting, for even enforcing that is not simply command and control.
Thanks, Pia. And next, Graham, your go. What should be top of the list for reform when we look at our copyright law?
Oh, I don't know. I was going to say that as soon as you put copyright in a sentence, the sentence is already boring. But that's very rude in a conference where people have said lots of very interesting things about copyright. If I had my wish about the legislative reform process, it would be that we would stand back and ask the question, well, what does a decent society look like? What does a vibrant, creative environment look like where we respect creative workers, where we respect people who want access to material, where we respect people who, for various reasons, including cultural commitments around Mātauranga Māori, are able to put restrictions on access, and just stand back from that and ask that question. Unfortunately, in the legislative framework, the lovely people at MB don't have the ability to stand back and say, well, what does a good, decent society look like? They're stewards of pieces of legislation. And so that whole question gets tied up in a question about copyright, which I think is very unfortunate. It's just one of the tools that a society has for creating a vibrant culture, right? But to answer your question, 92B.
Right.
Which is 92B is the section on Internet Service Provider Safe Harbours, and I just don't understand what it means. I'd like some clarification.
Yeah, that was an issue that also came up in that screen industry event, wasn't it? Balancing Copyright. George Ford, the expert from the USA, had a long conversation with him afterwards where I tried to get him to explain to me safe harbours, and it was a long conversation. I concentrated really hard, but it was still difficult at the end. Yeah. Okay. But Graham, while you've got the mic, I mean, the number one problem that's often pointed to with our law is its age, and, the fact that no law can keep up to date with the way laws are revised, periodically and so on, with advances in technology, particularly digital technology. We hear about online backups, cloud computing being technically illegal, or some aspects of cloud storage. Is there anything that can be done about that? You can never have a law, can you, that's going to keep up to date with all the...
Yeah, I think I'm probably the wrong person to answer, to address that question, because that has always been the problem. Every time there's been a new technology, the photocopier, the video player, the radio, there have been people who have said, this is the end of copyright, it's just going to crumble. And we sort of muddle through, and as a result of these kind of fabulous fora like these, people get together and they talk. hopefully sanely about these kinds of questions. So it's not one of those areas where I get particularly excited about the challenges of new technology, because some wise person said copyright has been technology's stepchild from the start, and we're just at another moment where we're trying to work this through. Right, but somebody else probably can address that.
I deal with this every day, actually, not just with copyright, but around things like DMCA, around things like, the ability to reverse engineer technology, the ability to do all kinds of stuff that we do in my world, in the tech and service design and delivery world. We right now are trying to fix a particular service. The service has basis in government, has basis in legislation. In the legislation it says a person needs to physically sign in front of a witness. Now, that becomes an immediate inhibitor to a digital service. So then we did a little experiment where we got the policy people, the legislative people, and implementation people in the same room at the same time and said, what on earth was the policy intent here? Why was the legislation drafted this way, and how would we interpret it? And the answer to your question is, rather than laws being created off in isolation, rather than legislation or policy being created in isolation, it is actually through co-design across different sectors, across different disciplines, and in particular with the people you expect to implement these things, where they can say, well, my interpretation is this the original intent? What we did through even just a short experiment in that exact process was we found a new way of drafting policy and legislation that could then actually be implemented in a way that was befitting the original intent. So if we actually co-design the drafting of these things, we have a better chance of laws that, for instance, don't say a physical signature, but rather get to the intent of making sure that, for instance, in this particular case, that there is some form of quality control in this particular case. So if we involve those people in the room, we'll have a better chance.
But does that only work when you've got it's public policy initiatives and public organisations that are accountable? I mean, if you're cutting across people's commercial interests or other,
Well, cutting across is an interesting zero-sum game way of putting it. I think that we get in the room. So the fact is that right now a lot of things are designed in isolation and in black boxes, from which you eventually something will emerge and say, hey, let's consult you on it. But why wouldn't we co-design these things together in the open, so that then anyone who's interested in the thing can say, well, hold on a second, I would interpret that very differently. So open development of these things, particularly when it comes to the rules and regulations and laws, that affect the entire society. Now, of course, how a company operates will always be up to a company, and they probably won't choose to operate this way. But if we're talking laws, if we're talking copyright, and if we're talking the rules of the operating system of the state, as it were, then developing those things openly and collaboratively and in a co-design way across different things will help with that problem.
Well, Corey, you have a nice saying about every pirate wants to be an admiral in relation to the technological habits, the possibilities of technology walking forward ahead of the law. Seeing as you've got the mic there, can you walk us through that? Because I think that you began that analogy right from sheet music right through to...
Sure. So, in industrial activity as opposed to artisanal activity requires a machine. That's what makes it industrial. So the first machines for reproducing music were printing presses for sheet music. And so the industry were the people who wrote the instructions for how to perform. And the craftspeople, who did something in their view that was relatively unskilled, was to perform the instructions they wrote on the sheet music. And so when these jumped up craftspeople decided to start recording these compositions, John Philip Sousa went to the American Congress and said, if these infernal talking machines are allowed to continue, we'll lose our voice boxes as we lost our tails when we came down out of the trees. And Congress did not have a lot of time for Sousa and his arguments. They created a kind of compromise in which they have a statutory license or compulsory license. You pay 2 cents per recording and you just get to use any composition. So that now you have this new industry, which are recorders, and the broadcasters come along and they start broadcasting these recordings without permission. And ASCAP, who represented all the legitimate artists, the white artists, BMI was the one that represented what was called race music and hillbilly music, so music for poor white people and music for black people. The ASCAP boycotted radio, and they said, when we took those, that sheet music and recorded it, that was the legitimate progress of the arts. But when you take it and diffuse it over the broadcast airwaves, that is theft. And then along comes the VCR, and the broadcasters, who at this point mutated into TV broadcasters, turn around and say to Sony, back when we were taking phonograms and modulating them over radio frequency, that was the legitimate progress of the arts. Now that you're recording them to magnetic tape in people's sitting rooms, that is piracy. And then, of course, Sony becomes a movie studio and sues Napster and the peer-to-peer file sharing companies and says, when we were doing it, it was progress, and when you do it, it's theft. And this kind of self-serving bias is like, it's a problem in all our lives, right? Sometimes it's called the fundamental attribution error. When I cut you off in traffic, that's because I had made an honest mistake. When you cut me off in traffic, it's because you're a dangerous, reckless driver who should have your permit to drive revoked. And so one of the jobs of policymakers is to cut through that kind of self-serving rationale, which may be sincerely believed by the people who espouse it. I'm not proposing that they're hypocrites, just that they're prone to human frailty. And maybe a regulatory framework for this, if we don't like the idea of fair use and having things adjudicated in courtrooms, slow and unwieldy, the US has an interesting kind of middle ground in its expert agencies that are part of the administrative branch, like the FCC, where they are required to gather expert evidence in support of any policy framework that they advance, and they are subject to litigation if they advance a policy without evidence. That's still, lots of room for mischief, but a good example of this playing out now is the chairman of the FCC, who killed net neutrality in the US after ignoring the main body of evidence, is now being sued for this procedural irregularity. So maybe what we say is, here's a framework by which we evaluate the fairness of a new technology. We have an expert agency that adjudicates it. They have to do so in the presence of evidence, and they're checked by the courts should they become captured or beholden to an industry, because they have to consider best evidence. Still an imperfect system, still potentially an expensive and unwieldy system, but if the consensus is that the lawmakers move too slowly, then maybe regulators can move more quickly.
So in that sense of every pirate becoming an admiral, is that once they're running an industry which is caught up with the technology and is exploiting it well to a commercial benefit, then that becomes the bedrock for whether it's legal or not.
I mean, Douglas Adams said that any technology invented before you're 18 was always there. Any technology invented by the time you're 30 is amazing and revolutionary and will change the world. And anything invented after that is evil and should be destroyed.
Is it like the equivalent of getting more conservative as you grow older?
I think we've all lived it, right?
Okay. And Vanessa, you've talked about privacy, and just as people are, still largely unaware, even after living as digital citizens for a while, about how much, or some people are, unaware of how much they're putting out there. Is it true that also people are unaware of how much they are copying? They are engaging in, copyright actions, either when they create something or just when they use it?
For sure. But I think the question as well is, when we're dealing with the intersection between privacy and copyright, why does society and the law value the commercial exploitation of a creative work more than it values the inherent right of someone to protect their own image or their own personal information? Because, for example, how many people have seen in a Google result, this page can't be displayed because of DMCA? Maybe no one. But how many people would know how to take something down because it infringes on privacy issues? No one. And so, for example, what we need is a similar privacy takedown, or maybe that copyright needs to look more towards the Privacy Act for how it should operate, which requires that not only is there an infringement or an interference with your privacy, but that you have to prove a certain level of harm before it will be investigated.
And Linnell, does that ring true for you? Because you'd have to bear in mind the rights of content creators, people who want to protect their work for reasons other than just the individual.
Yeah, it definitely does. I actually agree with what Vanessa's just said. I think there is this bias in society, in our intellectual property system, actually, to promote and protect business and commercial interests over personal interests, including Indigenous peoples, just to bring that into the conversation again. And there needs to be, it needs to change if we are to move in a way that Graham talked about at the start, to have a system that's fair and equal in every respect.
But legally speaking, if for Indigenous content or creations, is there any difference between that and the basic principles and any other content creator that might want to protect their work? Or are you saying that's how the law needs to change?
No, I don't. I don't think there is a difference. I think there just has been a bias towards that individual creator rather than an Indigenous people perspective.
Sorry, not to cut into that at all, but just back to the privacy thing just briefly. Certainly, privacy I think is seen as a it's really interesting in government. People talk about user consent. Okay, I have legislative power to do X, and so when I want to go beyond that, I'm going to get someone to consent so that then I can do to them what I wanted to do, but with their consent. That's a slightly cynical view on it, but consent is seen what you get when you want to do something that you don't have power to do. I think, again, flipping the model in government to user control, which actually starts to look at how do we empower individuals and indeed communities, and it's not about us empowering them, but how do we develop that together so that then individuals and communities can thrive rather than just government doing unto. So there's a rethink at a broader system view here, I think, and that's part of why I think looking at a lot of these things in isolation is actually a little bit of part of the problem. We almost need to think about where do we want to go, what do we need to get there, and then how do we transform these things? Otherwise, we're just going to iterate, the Copyright Act, then we'll iterate the Privacy Act, then we'll iterate this act and that act, but the underpinning systems and assumptions stays the same, which is where I get a little bit concerned.
May I?
Sure.
I wanted to say apropos copyright and privacy, as someone who very strongly believes in privacy rights and also I'm somewhat skeptical about a maximalist copyright, I worry that it's not a good fit. I actually think copyright itself is not a good fit for property regimes. I know that for the last 40 years, the only way we can describe something as valuable is calling it property. But the most valuable things we have are not property, right? My daughter is not my property, and people who assert that about their children are monsters. And so, but it's also true that I have an interest in my daughter, and she has an interest in herself, and other people in her community have an interest in her. And we have this whole set of legal offenses to describe what people do to humans that don't make recourse to property. We don't call rape theft of sex. We have things that express the uniquely bad elements of offenses committed against a person as opposed to the offenses committed against inert matter. And so I think that, for example, giving people property rights in phone numbers, although having your phone number leaked all over the internet can be terrible and even catastrophic, is a terrible idea. Like, people shouldn't own integers. But that isn't to say that we can't come up with a regime that deals with privacy in a way that tries to be protective of privacy. I just think looking to copyright for it is like, it's like throwing a drowning person an anvil. It's just gonna make it worse. And I did want to say, from my very limited perspective about Indigenous knowledge, because I'm not Indigenous, and I certainly think that your points are very well made and well taken. My only concern, having lived around the periphery of it a bit, is that in settler colonialist contexts, sometimes the authorities who have the right to authorize or prohibit the use of sacred Indigenous symbols are people who are contested by other people who consider themselves Indigenous. And that one of the great crises can be if you believe that the settler colonialist framework that establishes your identity is invalid and you want to criticize the putative leadership using Indigenous symbols. That is the leadership who has the right under those regimes to stop you from using it. And I don't know what the answer is, because I also think that we come up with these very arbitrary frameworks for which things are protected and which ones aren't. We say the melodies of European music are copyrightable, but the complex polyrhythm that characterizes, say, Afro-Caribbean music isn't, and so the Beatles can take R&B and that's legal, but Jay-Z can't sample the Beatles because that's illegal.
Yeah, and were the Police playing reggae back in 1980? Yeah. I mean, in Canada, actually, has this been an issue, just as you've mentioned it, with Indigenous people?
Yeah, I mean, indigeneity in Canada is contested because people, we have a recognized Indigenous category called Métis that is itself very contested, that is people who are nominally descended from French settlers and mostly Indigenous people from the prairies, but it's a very stretched definition, and sometimes it includes Inuit people and sometimes it doesn't, and so on. And the issue is, of course, that under the treaties, a tiny, insufficient amount of provision is made for Indigenous people. And so it's like a game of musical chairs. The more Indigenous people there are who are entitled to it, the less everyone has, and it breaks solidarity not always, but sometimes it can be a source of mischief.
Graham, you were going to respond to
I
what
was just
Corey
going
was
to follow
saying.
up on a point that Corey made earlier about property, because there's a whole other regime of law that touches on what we've been dealing with today, which is international human rights law. And so when much of the world was pulling itself together after the Second World War, we got the Universal Declaration of Human Rights, whose opening statement talks about the inherent dignity of all people, of all members of the human family. Article 27 of that instrument says that everybody has the right to the moral and material interests of productions of which he or she is the author. That's nestled within another provision, which is about access to the materials of culture and being the beneficiary of developments in science. And so of all things, when the world was trying to pull itself together and say never again, they were thinking about the rights of creative people and how those rights interact with all members of the human family's interaction with culture and access to culture. And so there's this whole other body of law that isn't bogged down with property frameworks, which I think is worth pausing and thinking about, and actually thinking that the inherent dignity of all members of the human family, the framers of that instrument said part of that is the rights in our productions, our works of authorship, the moral rights, the right to object to derogatory treatment, the right to use material that we've produced in violent video games today, but also the right to earn a living and to earn a living with dignity. And so if I was thinking about, what would a copyright regime be, I think we'd focus really sharply on what does it mean in society to value the creative worker. And how should copyright regimes respond to that, taking into account, I loathe the term balancing, because balancing is just, wherever your perception is, if you like it, it's balanced, if you don't like it, it's wildly unbalanced. But taking into account these questions of how in mostly capitalist society like ours, we have access to these materials, also taking into account the really valuable public sector organisations that organise access. We can get right away from property, but still have the same issues, and still debate the same issues with open hearts and minds.
Yeah, thanks, Graham. And Graham, you spoke there about the need to sort of take a pause on it. And with that theme in mind, I'm just noticing our live stream there has the transcription over the top, and sometimes it's struggling to keep up with us. So maybe as we speak, it's not just at you, but all of us, maybe we need to just speak a little slower, because I can just see the text.
We're all enthusiastic about this topic.
Struggling to keep up. Well, that's it. But I remember from the Nethui in November, where I was speaking, and I didn't actually realise that the text was coming up behind it. When I got to the airport, people had posted pictures of me on Twitter, which had all the garbage and the bluffing I was doing coming up in text behind me. It's a painful experience. But I wonder, you talked about authorship there, Graham, and some content creators, might find it a frustrating discussion, because people who, depend, have their livelihood, maybe finding their returns, getting undercut by technology and the way it's deployed. Corey, earlier today you talked about, trying to prop up business models or freeze them that are struggling today in the media or entertainment or any digital industry is not a creative way to go. But this did come up, Graham, didn't it, at the Balancing Copyright Seminar. Ruth Harley, just as an example, former head of New Zealand On Air and the New Zealand Film Commission, she said that the value of Kiwi content had been hollowed out in the digital era, while those disseminating the work online were making lots and lots of money. She said the disseminators are allowed to take out the value as opposed to the creators owning the value. She said these were her estimates. Over the last 10 years, the value of copyright in music, books and audiovisual content in New Zealand had dropped by about 35 to 40%, but then making the point the revenue of the likes of Google, Amazon and Apple increasing much more the other way. So she was saying the public interest isn't contrary to the creators' interest, which is that their rights, should not be hollowed out, and the public interest shouldn't be always in getting things for free just because technology makes it possible. Corey, do you think that's just an outdated argument and you're just howling against the wind if you're trying to resurrect previous arrangements?
Well, I don't recognize the figure because I don't know what numbers go into it. I've heard variations on this in other places. Oftentimes, as I said this morning, there's a creative sector that's spoken on behalf of by the investor class, the people who publish, who make great recourse to the amount of the pie that's being consumed by their industrial rivals on the distribution side, but who are strangely silent on the fraction of the revenue generated by the artist that goes to their own shareholders. And I am neither of the opinion that big tech has our interests at heart, nor that big content has our interests at heart. I think that, indeed, when you look hard at them, they have the same institutional owners. That like literally the same hedge funds and institutional investors are the majority shareholders in the majority of those listed firms. And so it's not like there's any, it's not like you can get a credit card between them, honestly. And so I guess my concern is that if we want to have an author-first model for copyright, we should be asking authors and not the publishers who are the conduit for our money, but who, all other things being equal, would take as many dollars as they can get away with and return them to their shareholders, not because they're evil, but because that's their fiduciary duty under our current model.
And Linnell, you're a lawyer. Content creators themselves, like the authors rather than the companies, they probably and oftentimes can't afford lawyers, can't afford to go after people that might be violating their copyright. Do they need to be better looked after?
You're absolutely, yeah, they definitely do.
I thought you'd say that.
And this would be doing probably my business a bit of a disservice, but I think access to justice is another big issue. That's wider than just the copyright forum as well. But I think one of the issues, particularly for authors, is actually just asserting your rights a lot of the time. It's just being proactive about it, and you can do that in ways that are not expensive and not using a lawyer. And in this case, Indigenous, Mātauranga Māori in particular, a lot of the time it's just about being proactive, identifying, calling people out on their misuse, and controlling it. I think we can, as most of you will remember, some of the misuse of Māori images that happened overseas. And Māori on cigarettes. That got pulled because there was an outcry. We didn't want the name Māori appearing on cigarettes in Israel, and it was just a real plea to be to the moral obligation on the manufacturer. And I think
that's not about money or
no.
rights. That's about associations, which are
that's right.
damaging.
Yeah, that's right. And I think that the same should apply in a situation where you do have an authorship and a creative role in producing a piece of work.
Sure, Pia.
Just quickly, I think there's also important that we take a slightly, possibly improve the maturation about what we mean by the things covered by copyright. Because, of course, talking about authors or creators is one aspect, but in Australia has one of the best preserved copies of the Magna Carta in the world. In digitising it, they decided to add copyright to it, crown copyright to it, and arguably it's out of copyright.
Sorry, Pia, what was the last
The
one?
Magna Carta is arguably out of copyright.
Okay, out of copyright, yeah, let's hope so.
You would, and yet they applied crown copyright to it because they came from the perspective they needed to protect it from the hordes of people that might deface it or use it on postcards. But our perspective was, well, right now the official copy of the Magna Carta from Australia is someone's flip phone, on Wikipedia. So actually, that's a different use case, right? And in the US, they have a very different rule. Basically, the transition of medium doesn't apply to new copyright, but that's not the case in Australia, and I'm not sure what the case is here, still learning. But there's also things like public research. The fact that a publicly funded researcher, academic, has to spend more money to publish the outcomes of their research, their papers and their data and such, than if they just put it into a paywalled journal. We've got this weirdness at the moment that the conversation always comes back to creators and authors, which is an important, very important part of the conversation. But where we apply copyright now is kind of weird. And just as a quick side note, I used to be the president of a thing called Linux Australia, the little community of geeks in Australia. But
So what was it called there, Pierre?
Linux Australia.
Linux,
So,
okay, yeah.
we're talking proper nerdism, it's awesome. Anyway, we got a takedown notice from the MPAA. We got a takedown notice saying, you are obviously distributing copyrighted rights. And we're like, what? What their little machine, Autobot basically did was find in a repository of software a little tool called Valgrind, which is the tiniest little couple of kilobits, sort of size thing. And they said, oh, obviously that's the movie Grind, which is some C-grade awful thing about, skateboards. Anyway, so we got an automated takedown notice, right?
Okay.
And of course we said, duh, this is ridiculous. And they're like, oh, the onus is on you to prove that you haven't, broached our copyright. So we took it to the media, and then we got an official apology because that was the way that we decided to play that game. But people then having to defend themselves against how it's applied right now by these, not necessarily creators, often enough those distributors who are trying to maximise the profit and such. So again, what do we apply it to? Shouldn't publicly funded stuff be publicly available? We had 200,000 years of evolving through cooperative sharing of our knowledge and being able to build on the shoulders of giants, and yet we're locking away some of our most, certainly publicly funded knowledge, and then wondering why we have a community that can, that doesn't build on the back of all of that collective knowledge. We've, again, broken systems lately.
Actually, seeing as you raised it, you mentioned journals there, and at Nethui last year, Ryan Merkley from the global head of Creative Commons was here speaking, and the thing that got him wound up more than anything was academic journals and the whole academic publishing industry, and there were some eye-watering sums involved in that I was unaware of. He said, I've copied it out here, if the system of academic publishing we have today was proposed, it would be scandalous. The publishers take the copyrights and sell them for huge fees to libraries and individuals. The knowledge that we create should pay for itself and be available to us all. And he'd written an article about it called You Pay to Read Research You Fund, That's Ludicrous, because a lot of the research was carried out at publicly funded universities or institutions and by scientists and experts employed for that purpose. I wonder, does that show that where there's something that really has a high market value, it can still be locked up, and copyright law really protects that? There wouldn't be any easy way to undo that?
So because the success criteria for all of this is fundamentally seen as economic, that's part of the problem, which goes back to Corey's point about value not just being economic. So the value of publicly available research arguably would be public good and the ability for public innovation, and it's already been paid for once. Why does it need to get repaid for over and over again? People have railed against that for a long time, but right now the onus is on the individual research to go into their own pocket, because their institution won't pay for it, in order to take something that they've written and have it available in an open journal. And even then, the open journal that they use won't be as highly esteemed as the private one, which just happens to be the same one that university publishes and charges people to access. So it's a perverse system right now, and it is not serving the public good. So one would ask, why is it publicly funded? But that would be getting very contentious.
And Graham,
and in some places it's not. In the UK now, you can't get funding unless you're publishing in an open access journal. The National Institutes of Health in the US have declared that they will not give public money unless the outcomes are in open access journals.
That's not the case here yet, though.
And in some cases, all it takes is just moving the budgets around, because the library, you take the $50,000 the library would have spent on a subscription to the journal, and you turn it into $51,000 open access review fees, and it's a wash for the university, except that science becomes very widely available. I think that's not a bad answer. There's an interesting quirk about all of this, at least in the US, which is that until relatively recently, like the 1970s, the arrangement under which professors produced, researchers produced at universities, was a work made for hire arrangement. They were considered employees, and the universities held the copyrights in their work. The contracts the professors signed with the journals assign the copyright on behalf of the professor. The professor had already assigned their copyright. They didn't own the copyright at that point. Only the university could do it. And copyright in the US is strict liability. It doesn't matter if you got a signed contract from someone who purported to own the copyright if they didn't own the copyright. The actual copyright holder can still come after you.
So does this mean the individual universities were enabling this whole arrangement?
No, so they turned a blind eye to it.
Okay.
They didn't insist, but contractually it was completely improper. It's as though I sold your house, right? The university owned those copyrights. The university professors sold them on their own behalf, claiming that they own them. Now, they indemnified the journals, but they're dead, right? The journals can sue their estates. They don't have, these are university professors at publicly funded universities. Their estates are largely worthless at this point. And the statutory damages for copyright run to $150,000 to $250,000 per download for all of those articles. So just one American publicly funded university could, in theory, extract sums equal to multiples of the planet's GDP from all the major academic publishers for this irregularity.
That'd be a good one for the lawyers, wouldn't it?
Well, presumably it would result in a licensing arrangement.
Right. Graham, actually, when you opened my eyes to the fascinating world of copyright history back in October, from memory, initially it wasn't all about actually restricting publication rights. It was about opening it up, wasn't it? In the earlier days, or even back 18th century.
How long have we got?
Go on, give us the Gilded Station.
Yeah, 21 minutes.
That's right. I mean, to some extent, what copyright did is just create a monopoly in what we call now a trade guild for printers. But I mean, part of the quid pro quo. I mean, historically, part of the quid pro quo for copyright actually has to do with censorship. Is for authors to get the rights, they had to identify themselves. And so in times when it was dangerous to say anti-government things, there was a lot of anonymous publication going on at that time. And part of the deal was the authors said, look, we want a source of income from the copies that are sold by the printers, and part of the quid pro quo will be we will identify ourselves, so you will know who's writing this seditious material. So it's a more complicated story than that. But I think the early days of copyright was that the printers wanted to maintain their monopoly over their ability to print copies, and they were licensed by the Crown to be able to do that.
And while you've got the mic, the Deloitte report that was released earlier today at this very event looked at the issue of fair use and the possibility of an open provision for that. Do you think it's something you would favour in any reform of the copyright law? Because the report talks about US, Israel, South Korea as countries that have followed that lead, and talks about the possibility of a net economic benefit. But beyond the economic benefit, is it a good idea?
Gosh, that's a very difficult question, and it goes back to my initial comment, which is to some extent fair use is a sideshow. It's a sideshow because it's in many ways a procedural concept. It's delegating responsibility over exceptions from the legislature or from a regulatory body, maybe, to the courts. It's not actually about substantive outcomes.
Does it mean that we could have endless legal debate and challenges about the nature and the breadth of exceptions or exemptions?
Well, in theory, but Linnell's point about access to justice is a really important point, is that the players in litigation will be the people who can afford very, very expensive barristers with very, very expensive daily rates arguing over all of these things. So, I mean, to me, the fair use debate has very little to do with the broader question, which is what kind of culture, what cultural environment do we want in New Zealand? It's not about substantive outcomes. And I think the cynic in me is the people who push fair use are thinking about substantive outcomes because some of them, not all of them, but some of them are attached to these people with vast amounts of money to spend on litigation, so they can push and push and push until they get the substantive outcome that they want. That benefits the individual creative author whom we want to be independent, having a living so that she can put food on the table. That benefits her not at all. She's not going to litigate over whether she can use a particular use more than a substantial part of a particular work. She's not going to litigate that. A big platform is going to litigate whether or not they can use creative content freely or have to factor in the value of that content into their bottom lines. So it's sort of, I'll go on record saying I am in favour of fair use where it will genuinely enable people to use creative content in ways that they would not, to create new works of authorship in ways that they would not have been able to use it without an exception, especially where there is market failure, especially where I'll just tell you very, very briefly. I sing in a choir in the United States. There's this wonderful thing called the Harry Fox license, where you can almost instantly get a license to re-record a song. It goes back to that compulsory license that Corey mentioned. There was one song, it was a Disney song, and Disney had exempted itself from the Harry Fox system. I spent days trying to get a license for this stupid song so that we could put it on the CD. I got there in the end because I can be very persuasive, but many people would have walked away from that.
You talked down Disney.
Well, no, I found somebody who would, tell me that they paid a certain amount of money, we could record it. Many people would have given up because the transaction costs are too expensive. They don't have 2 days to sit on the phone with a Disney executive or find a Disney executive to do that. When the transactional costs are higher than the value of the use is foregone and we all miss out. But if people are able to, pay in this case, it was about, I can't remember what the fee was, it was about $30 per song. That's not an access to culture problem. That's not a fetter on creativity. So I'm very interested in fair use where it would enable new works to be created that wouldn't ordinarily have been created. I'm not interested in fair use, I think it's a much more complicated question, where it enables large tech companies not to factor the value of the content into their bottom lines.
Can I add one thing to that? Just as someone who gets copyright thrown at me and the work that I do in tech, I think that the danger of saying I totally agree with everything you've said, but the danger of let's imagine the cultural world that we want to see that allows, individuals and communities to thrive culturally.
Pia, so I'm just going to pause you for a second. The transcription is struggling to keep up with you.
And it always will. I'm not writing for machines, I'm writing for you.
Yeah.
All right. So the challenge of, and it's my accent too, the challenge is if we limit this around designing for the sort of cultural thriving, right? Then we miss the fact that copyright is being used as a weapon against things like 3D printing, right now. So I actually think we need to think broader. What is the sort of society that we want? Because for instance, the person struggling to eat, we've had 3D printed kidneys, actually printed and successfully transplanted and working. 3D printed food, if you get nanotech and can actually deconstruct and reconstruct molecular materials, which we're not that far from doing. We're 3D printing diamond filaments for new buildings right now. It's not just like we need to think in the holistic approach to what a good society looks like, so that then when we build these kinds of frameworks, we're doing it in a way which doesn't create a zero-sum game between culture and technology because they're both part of society. Does that make sense?
Sure.
Cool. Sorry.
And Vanessa, you have any thoughts on that fair use regime? And Lynelle, would that make a difference for you as a lawyer?
I mean, I think there's a case there's been a couple of cases actually in New Zealand on fair use at the moment, and raising some interesting issues that I think Graham has covered off pretty well. I guess it could potentially create more work for lawyers in a lot of respects, but it is an interesting debate, and I think it does go back to, I agree with what Graham and Pierre have said. It goes back to the framework that we have. What do we really want that to look like, and what are the outcomes we're hoping to achieve from it, and does fair use fit into that?
And do you think that the copyright law review that we actually have is likely to go that broad and can take that stuff into account?
Katrina says yes.
Katrina says yes.
Cool, that's
awesome.
official.
I think that they do. I would love them to take a step back and really examine from a first principles copyright law what that would look like. That would be an exciting challenge for the team, but it also presents a great opportunity for New Zealand to be, world leaders in areas such as fair use and other areas as well.
I wanted to mention an example of how fair use can work well, or how failures in fair use can be remediated. In the US, one of the crises of fair use is because it's so fact-intensive, errors and omissions insurers are very worried about anyone they write a policy for who relies on fair use. And so people who make documentary film are routinely required to clear things that are fair. And it's very expensive, and it also gives people who are the subjects of documentaries, often critical documentaries, the power to refuse to authorize the use of their image or their corporate logo or other materials that would be fair use, but that the errors and omissions insurer won't let them put it in the movie. And this has to do with strict liability and the fact that everyone in the chain wants to be indemnified because the aggrieved party can sue the cinematic exhibitor or the distributor or the filmmaker, whoever has the deepest pockets, because of strict liability. And
does that, sort of interrupt you there, Corey, does that then mean that the documentary maker might just think, oh, well, in that case, we don't want to be tied up with this. We will remove individual acts
That's
or
right,
Corporation
yeah.
Y from our story.
They make bad choices, suboptimal choices.
Or
And
is it even a means of delaying
Yep, that
the
too.
production?
Yeah,
if they insist
all
on it?
of the above, yeah. And it also curtails what kind of movies you can just raise money for, because people look at your plan and they say, you'll never get insurance for it. So enter the Stanford Fair Use Clinic, where you have a professor who has a bunch of grad students hanging around like a bad smell looking for something to do research on. They articulate a set of best practices for fair use in documentary film, and they put it out to the insurers that they will provide free legal services to anyone who adheres to these rules if anyone ever wants to sue them. And one of the reasons that this is so ambiguous is it's rarely the subject of litigation. It's more often the subject of threats. And so we don't have the jurisprudence that tells us where the contours of the law lies. So they win no matter what happens. So either no one gets sued, in which case we get the movies, or someone gets sued and they get to adjudicate it, and we find out where the contours are, and they're going to inevitably be narrower than they're being placed now. And the insurers who want to write policies on movies their competitors won't write policies on, because that's money in their pockets, look at this and say, that's an opportunity for me. Now, unfortunately, that prof moved on and that fell apart, but it's not a model that's hard to imagine how you'd repeat it in other contexts. And, law clinics are how you make good lawyers. Academic training is great, but lawyers who go through law clinics and universities graduate ready to practice law, not ready to go an article for a firm for 3 years.
And Corey, while you have the mic, in Canada, they have had the Copyright Act amended in 2012, scheduled was reviewed last year. I think still that'll be ongoing. And they had a major report about the state of the news media, which seems to have problems similar ones to other countries, including this one. And one of the recommendations of this major report, sponsored by the government, was to change the fair dealing provisions that they have in their Copyright Act in Canada, to tighten the use of copyrighted news material in favour of the creators, without unduly stifling the social power of sharing on the internet. News producers have a right to benefit from their work for a reasonable period. So basically they want to prevent news being ripped off and being used on other platforms, or possibly even it raised things like link taxes. If you want to link to it, maybe you have to pay something back to the creator. Would you support any of that? Is that workable?
I mean, I would like to swim underwater and not get wet too, right? I mean, yes, we'd like to give people exclusive rights over the news without unduly affecting public discourse. That sounds like a great idea. Let me know when you have a detailed plan beyond a slogan, and I'll let you know how it sounds. You know, the Canadian news media is in trouble. It's in trouble for a bunch of reasons. One is that we had 12 years of Tory rule during which the CBC was gutted and our local news fell apart. They were the broadcaster of last resort, especially in our rural areas. Canada is a very large country with low population density in much of its territory.
The CBC is a fully publicly funded
entity. We have other problems. Vulture capitalists bought up our major newspaper chains, loaded them up with debt, and are now paying themselves debt service.
Is that working out well?
Well, they've strip mined the newsrooms. They were allowed to merge. They're all merged up. So the ISPs own the papers, own the major web portals, own the TV stations, and they've been allowed to merge those conglomerates again and shut down local newspapers like crazy. They've gutted their local newsrooms. Nobody wants to take in the paper anymore because it's thin and it has no news in it. And then these vulture capitalists sold off all the assets of our major national newspaper chains, are renting them back at scandalous rates, and then gutting the pension funds of their unionized employees to pay off their bonds. They're American firms that have come in and done this. And again, like, I don't want to bang on it, you know, like jam yesterday, jam tomorrow, no jam today. Like, yeah, we should have news media before we fix late stage capitalism, but this is peak late stage capitalism, right? We are not going to fix this problem of the newspapers by giving exclusive rights over facts. For one thing, all of these newspapers subsist at this point by rewriting each other's stories, right? And they are falling prey to that kind of self-serving bias where they're assuming that they will be able to prosecute people who rewrite their stories, but no one will ever think to prosecute them, because when they do it, it's legitimate news gathering. When other people do it, it's just petty thieving. It's not a very good piece of policy. And it's in some ways the Liberal government is trapped by the legacy of 12 years of Tory rule in which all of this mergers and acquisitions happened. But I think they could have done better. I hope they will.
So amending fair dealing provisions in the Copyright Act will not save the news media. That's the takeaway.
Yeah.
Graham.
Colin, just on that, just by way of clarification, statutory damages are only available if the copyright has been registered. And so if the copyright has been registered, then there is somebody that you can ask a license for. Mercifully, in New Zealand, we don't have statutory damages. The real problem for downstream innovators is not really the license fee, it's the threat of an injunction. And so the whole investment in the production can crumble because you have to pull the thing, and copyright owners do have the power to seek an injunction. A quick fix in a country that doesn't have statutory damages is to have good faith efforts to find the copyright owner of the archival material you want to use. If you do that, you come up with nothing, you use the material, take away the injunction. If the copyright owner comes out of the woodwork eventually, I suspect that our courts would look not too fondly at them and just give them what would be a fair license fee, which with archival material would be almost nothing. It would just be delaying the costs that they could have paid up front. So there is, if you limit the power of injunction and just say it's a fair license fee for archival material, it's almost nothing, then the real risk to the downstream creator has been taken away.
Although in documentaries specifically, there is the risk that people won't want negative treatment of their choices trade.
Oh, sure, but that's a different matter. That's a reason why there's market failure, and you should have a defence, because that's why you have fair dealing for parity as well. Because no one, very few people, unless you're Weird Al Yankovic, no one licenses the material to be lampooned. But that's a different question. That's a market failure problem, and I would have no sympathy with the copyright owner under those circumstances.
Can we talk about a fair dealing exception which no one has for tribute? So right now you're allowed to write fanfic that rubbishes something, but you're not allowed to write fanfic that expresses your love for it.
Yeah.
You're not?
No, that you're expected to have a license for that.
Oh, okay. Well, look, we are coming up towards the end of our time for this session. If there is a burning question that someone has for any member of our panel, then please go ahead. We have our big, fluffy roll of the dice microphone. Peter.
Speak into the microphone. Not too
Is this all right? Thank you very much for an extremely interesting session. My question stems from an online search I did recently for some copyright image material. And I forget whether it was Getty Images. It was one of the big licensing firms that dealt with photo images. And partly just out of curiosity, I put in a search for New Zealand and found some interesting references to Maori imagery that came with a proviso that the images could only be used in ways that reflected Maori culture in a positive way, or words to that effect. And I wondered if you might comment on that, I mean, particularly Linnell. But the broader upshot of that is that I think that has implications for the idea that copyright isn't just an individual right, that there might be a collective community right to certain sorts of material. And could the panel please comment on that?
What I can assume has happened in that situation is that the creator or the person who took the photo has required that be a condition of the uploading of the photo, and that and people can use it if that condition is met, which I think is a great thing. I think that ability to be able to have an added level of control in a situation like an image that involves a Māori image is wonderful, and it certainly complies with some of the things we were talking about in the earlier session today about tikanga and kawa. That would be a natural process there, and I guess for me, from a Māori perspective, community ownership of Māori knowledge is a well-known concept in Māoridom and in Indigenous peoples' societies. It's something that they are very familiar with. People hold, they don't own works, they hold as a kaitiaki, as a guardian for future generation, and that is something that is very familiar and very common. And so it is only the legislation that we face with that introduces this individualist ownership model that is actually quite contrary to those traditional community-held beliefs.
We didn't speak about Creative Commons, but that was mentioned in the Deloitte report today as they described it, I think, at least a partial solution to some of the problems that we face in changing the law. And I mean, that has more than 1 billion works now, I think, in circulation, able to be used under this sort of some rights reserved system, but they're not often sort of qualitative concerns like that, are they? It's just about the breadth of the distribution that the creator allows. Probably got time just for one more. Sir. Good catch. Good throw, yeah. Oh, yeah. I took that for granted. With the greatest of ease.
Lots of stuff about copyright, lots of stuff about potential changes to copyright, some quite radical ideas and some quite sort of smaller ones. But at the same time, I'm sort of very conscious of the fact that we feel completely oppressed by all the treaties, the world treaties that were signed and so on. And we're part of it, other places in the world, and there seems to be a feeling that maybe there's actually not much we can do. Has the world locked ourselves into this current copyright regime?
We made it all, we can make it again, so let's do that. We need to make it all again. I think the world is at a weird tipping point right now where it has become extraordinarily apparent that the systems in place at the moment are not sustainable, and so we need to have a think about how to make them sustainable. So we need to reinvent these systems, otherwise we're just going to maintain the trajectory that's not so much working for everyone.
I would love to. I acknowledge your concerns. I think the fact that WIPO and WTO and GATT and TRIPS, we have all these requirements, and there's a whole, even UNDRIP and UNESCO, we're signatories to a whole lot of conventions there that put in place a lot of requirements that we actually don't comply with at the moment, or we haven't ratified, I should say. There's so many out there. Navigating that minefield of treaties is going to be very difficult. And then we also have the fair trade agreements that impose a lot of requirements on us. So it is a big job to navigate, but you can still be creative within that space. And so I agree with Pierre, there is scope for us to do so.
Thanks, Danielle. You want one last word, Corey?
Just briefly, the Marrakesh Treaty started off as something called the Access to Knowledge Treaty, and I was there when we started that at the Médecins Sans Frontières offices in Geneva. And Jamie Love, who convened that meeting, who runs Knowledge Ecology International, someone asked him why he had gotten us all together on a Sunday in Geneva to write a treaty that would never be passed. And he said, look, the WTO was written by a group of people no smarter than you, less than a kilometer from here, who gathered in a room on a Sunday, and that's how it kicked off. So this is how we got here. The reason that the treaties that seem to express the interests of narrow, extremely wealthy people are the ones that we abide by, and the other conventions are the ones we never ratify, is in part that we have an enormous degree of wealth inequality in the world that changes the calculus of power. And part of that is something that Kiwis have to put their hands up to, because this is a financial secrecy jurisdiction to rival the British Channel Islands, Wyoming, Delaware. And the Panama Papers could just as easily have been called the BVI Papers or the New Zealand Registered Limited Ownerless Company Papers. And you do have one area in which you can make a direct change to the balance of global power, and that's in challenging financial secrecy here within your borders as a way of uncovering the paths that this money takes in the policy, in the process of policy laundry that gives us these bad outcomes.
I'll just make one last quick point as well. I think it's very easy to get very to feel really disempowered by all of it and the weight of it all. I feel very optimistic because one of the converse things that's happened is that we've seen a massive distribution of power from the centre to the periphery. Distributed power of publishing, the power of sharing, the power of connecting to people all around the globe to create new social movements, new everything. The power of monitoring. It's not just from top down. People are monitoring up and people are monitoring sideways, and that's a whole different thing. The power of enforcement. Individuals, a couple of kids with a computer can disrupt entire economies, and that might be seen as good or bad, but it is a real power, and it is a real distribution of power now that didn't exist 20, 50 years ago. And finally, I think we're moving into this era of distribution of property, which of course is, I see particularly around 3D printing and that kind of stuff as a big part of that. So we are more empowered individually than ever before. What we need to do is to use that to create better worlds, more equitable systems. Otherwise, we end up just using our power in the same old ways, is what I would suggest. So I feel very optimistic, actually, that we are in a better position to be able to do this than ever before, particularly with some of the shifting global systems that were put in place 70 years ago. There's some shifts happening there, and we could use that to actually, to everyone's advantage.
Thanks very much, Pia. I'm afraid our time is up today, but thanks, you've given us tons to think about for the future of copyright. So our panellists today were Graham Austin and Pia Andrews, Vanessa Blackwood and Linnell, forgive me. It's on the sheet. Linnell Tafurihuri, I beg your pardon so much. And Corey, special guest. You've been working hell of a hard since you've arrived on this side of the world. You've done shows in Australia, Readers and Writers Festival as well. We've done the Office of the Privacy Commissioner. Tomorrow? Okay. Well, you've earned it. You've been working very hard. But thanks. Give them all a hand. Thank you very much, everybody.
you for the transcribe.